My name is Claudia Morrow. I am 66 years old. This past Easter, in my own dining room, my daughter-in-law handed me my mother's apron and asked me to go check on the ham while she poured champagne for her mother at the head of my table. Then she raised her glass and told 11 people, in my house with my dishes, using my grandmother's lace tablecloth, that my husband's trust was handled and the money was in good hands now. She meant her hands, hers and my son's. I smiled, I took the apron, I went to check on the ham. And I want to be clear about something right now, because people always assume the wrong thing. I was not blindsided. I had known this was coming for exactly 43 days. What I had not decided yet, standing in my own kitchen with the oven at 325, was exactly how I wanted it to land. I spent 32 years as an estate planning paralegal at a firm on Campbell Avenue in Roanoke, Virginia. 32 years of reading every line before anything got filed. 32 years of being the one who caught the errors before they cost someone everything. I retired in 2020, 2 years before my husband Martin died, and when Martin passed in February of 2022, I had already been managing the paperwork of our shared life long enough that grief and administration ran on separate tracks. I cried in the bedroom. I handled documents in the study. The two rooms did not interfere with each other. Martin was 69. He had a heart condition we both knew about and one we did not. The one we knew about, we had planned around. The trust had been drafted and executed in the fall of 2003. Our house on Clover Hill Road, the investment accounts, the retirement funds we'd rolled in over the years, all of it in the trust, with me as sole trustee after Martin. Simple. Clean, the way good documents are supposed to be. My son is 42 years old. He manages a chain of fitness center franchises, 3 locations in the Valley, a 4th he opened in the spring of 2023 that had not yet hit the projections he told the bank it would hit. He is not a bad person. I want to say that before I say anything else, because everything that follows becomes smaller if I do not say it. He has a genuinely good heart and a wife who has been navigating it for the last 9 years in a particular direction. My daughter-in-law is 38. She runs a marketing agency out of their house in Salem, and she is very, very good at making a plan sound like an act of care. I noticed this early. I did not say much about it because my son is happy with her, and because some things are not my territory to mark. Her mother, Rowena, is 64. She moved to Roanoke 8 months before last Easter after her second divorce was finalized. She needed a fresh start, my daughter-in-law said. She needed family nearby. That was true. What was also true was that by October, Rowena was at my table every Sunday. By December, she was sitting in Martin's chair. Not moved there. Just there, the way water finds the low place, gradually and without drama. And my son sat next to her and poured her coffee and called her by her first name like he'd known her since childhood. I am not a woman who fights over chairs. I have sat near the kitchen at my own table for 3 years, and I have not made a production of it. I have a slight limp from a car accident in 1998, and the shorter distance across the room is a real kindness, and I know it. What I have noticed is that the kindness is never offered without an audience. The document arrived on January 14th. I had been home 4 days from my knee replacement surgery. My right knee, the worn one, finally passed the point where the surgeon we had been discussing it with for 2 years said we should wait any longer. The procedure went well. The recovery was progressing the way recoveries do. I was on a prescription for oxycodone for the first 7 to 10 days, standard, post-surgical, nothing out of the ordinary. And I was sleeping in the recliner in the living room because I could not manage the stairs yet. My son came at 2 in the afternoon. He had a manila envelope under his arm, and he did not sit down, which is what he does when he has not planned to stay. He said the firm had been in touch, meaning Blue Ridge Trust and Wealth Management, the company that administers our accounts, and that there were some updates needed to make sure everything was properly in order now that Martin had been gone nearly 2 years. He said it the way you say something about a car registration. Routine, overdue, nothing to worry about. I asked him to hand me the envelope. The document inside was 8 pages. I read all 8 pages. It took me close to 20 minutes because the oxycodone made my eyes soft at the edges, but I read every word. I have read documents in worse conditions. The substance of it was this: a trust amendment designating my son and my daughter-in-law as co-trustees alongside me, with full authority to make investment and distribution decisions by majority vote. My majority vote. 3 trustees named. 2 of them shared a home and a checking account. I turned to the signature page, a line for my signature as settler. Below that, a date line. Below that, a witness block. 2 lines, both blank. At the bottom, a notary acknowledgement block, also blank. I looked at those blank lines for a long moment. I have looked at that same block. Witness signatures, notary seal, commission expiration date, on documents every working day for 32 years. I can read it the way some people read a clock. Then I picked up the pen my son had set on the side table next to my water glass. I signed my name. Then, the way I have done on every document I have ever touched since my first year at the firm, I wrote the date and the time beside my signature. January 14th, 2:19 p.m. My son looked at the page. He said, "You don't have to write the time, Mom." I said, "Old habit." He took the envelope. He thanked me. He said he would get it submitted right away. He left, and I listened to his truck turn out of the lane, and I sat in the recliner with the heating pad on my knee and thought about those 2 blank witness lines and that empty notary block for a very long while. I did not call anyone that day. I was not in a condition to make good decisions with my voice, and I have learned over 66 years the difference between knowing something and being ready to act on it. I let that afternoon go. What I did instead was think about a woman named Maud. Maud spent 31 years as an estate attorney at the same firm where I worked. She is 71 now, still consulting part-time, still the sharpest reader of a trust document I have ever sat beside. We had lunch every 3rd Thursday for 18 years. When I retired, she came out to Clover Hill Road with a bottle of white Burgundy and a card that said, "Finally, someone who will stop catching my typos." She was the person who, in my 3rd year at the firm, taught me to write the time next to every signature on every document that mattered, because dates alone can be challenged and times almost never lie. She also taught me this: in Virginia, a revocable trust amendment must be executed with the same formalities as the original trust. Our trust was signed and notarized in 2003. Any amendment required the same. A witness block left blank is not a minor oversight. A missing notary acknowledgement is not a clerical error that can be corrected after the fact. It is the condition on which the validity of the whole document rests. I had 32 years of that knowledge sitting quietly in my chest while I watched my son carry that envelope out to his truck. Welcome to Strong Mom Stories, the channel for women who kept every piece of paper and knew exactly what it said. Drop a comment and be sure to subscribe. Easter Sunday, April 20th. My daughter-in-law arrived at 9 in the morning with Rowena, 2 grocery bags of things she had cooked at her own house, and a centerpiece of yellow tulips that she set in the middle of my table after moving my grandmother's blue willow serving bowl to the sideboard. She did not ask. She moved it the way you move something that is simply in the way. Rowena went to the head of the table. Martin's End. She has been sitting there since December, and I have not said a word about it, and I want to explain why, because I think people expect the explanation to be weakness. It is not. It is the same reason I did not correct my son's paperwork on January 14th. A person who believes you have already surrendered will stop being careful. They will tell you things. I was placed at the far end, near the kitchen door. Easier for your knee, Mom. Which is true. 11 fewer steps across the room is a real thing, and she has never given that gift without an audience, and I have accepted it without comment every time, because some gifts are best received quietly. 11 people. My son and daughter-in-law, their daughter Phoebe, who is 14, their younger son Rowena, 2 of my daughter-in-law's cousins I had met perhaps once before, a neighbor couple they had invited, and me. My son sat next to Rowena. He poured her juice before anyone else. He asked about her knee. She has a bad knee as well, which became the topic for nearly 10 minutes while I sat at the far end with my hands in my lap. Nobody mentioned my knee. I had surgery on mine 11 weeks earlier. Phoebe came and pulled out the chair beside me and sat down during that conversation and put her elbow on the table and did not say anything, just stayed there the way a 14-year-old will when she does not know what else to offer, but knows something is needed. She has her grandfather's eyes. She also has his habit of reading things slowly and all the way through to the last line. My daughter-in-law brought the champagne out at 11. She went to Rowena first. Filled the flute to nearly the rim, the way you fill a glass when you want the room to notice the generosity of it. Rowena put her hand over my daughter-in-law's wrist, and they exchanged a look that had been practiced many times. Then my daughter-in-law came down my side of the table. She poured for the cousins. She poured for the neighbors. She stepped past me without stopping and went to the sideboard. When she came back, she had my mother's apron folded over her arm. Yellow and white stripes, a little faded now, a grease stain near the lower hem that has been there since the summer of 1987, and she held it out with a warm smile. "Mom, the ham really needs someone watching it. You know how your oven runs hot on the left side. You're the only one who knows its moods." It was a compliment. That is the thing I need you to understand. She was genuinely complimenting my knowledge of my own oven in my own house. That is the sentence that is hardest to fight. The one that has a real kindness wrapped around the part that isn't. I took the apron, I put it on, I went to the kitchen. I did not slam the door. I have never slammed a door in my life. I have spent 66 years learning that a closed door reveals more than a slammed one. And the kitchen window in my house looks directly into the dining room if you position yourself at the right angle near the counter, which I have known for 31 years. I watched my daughter-in-law stand at Rowena's end of the table and tap her glass with a butter knife. A table goes quiet for a woman holding a glass. "I just want to take a moment," she said, and I watched her say it from my own kitchen with my mother's apron on and my palms flat on the tile counter. This family has been through so much, and this year we finally have things the way they should be. Nolan has worked so hard to make sure everything is organized. The trust is properly handled now. The investments are in good hands. Then she said the number. She said it the way you say a number you have been looking at for a long time and are finally pleased to say, out loud in a room. 1.6 million, family money, where it belongs. Rowena raised her glass. One of the cousins said something I could not hear from the kitchen. Phoebe did not raise her glass. She looked at her mother, then at her father, then turned and looked directly through the window at me. I did not move. I was standing very still with my hands on the counter. My son did not look at me once, not once, from the moment the toast started to the moment it ended. A man who cannot let his eyes find his mother for 60 seconds while his wife announces at her table that her money is theirs now has already decided something about what he owes and what he doesn't. I turned back to the ham. It needed another 18 minutes. Here is what I need you to understand, because everything that follows depends on it. I was not humiliated into silence. I was not shocked. I had been waiting 43 days to see how far they believed they had gotten, and now I had my answer. They believed they had gotten all the way. They thought the amendment had been filed, accepted, and recorded, and that the number was theirs to announce over mimosas while I stood in the kitchen in my mother's apron. What they did not know was that Blue Ridge Trust had sent me a letter. 16 days after my son took that envelope out to his truck, a letter arrived at my house from the Trust Administration Department at Blue Ridge. I am the settler of record. I am the trustee of record. All trust correspondence comes to my address. My son did not know this, or he forgot, or he assumed that a woman 4 days out of knee surgery and on a prescription painkiller would not open a letter from a trust company in a timely way. The letter was written in the careful, measured language that financial institutions use when they are declining something without quite using the word decline. The substance of it was this: we have received a trust amendment purportedly executed by Claudia Morrow as settler. Upon review, this office has determined that the amendment does not include a notary acknowledgement as required under Section 9.4 of your trust agreement and applicable Virginia law. We are unable to process this amendment as submitted. Please provide a properly executed document at your earliest convenience. I read that letter 3 times. Then I placed it in the fireproof box on my closet shelf, behind the original trust agreement, behind Martin's death certificate, behind every piece of paper that has mattered in this house since 2003. Then I called Maud. Maud said 5 words when I finished. "You wrote the time, didn't you?" I said I did. She said, "Good, come see me Thursday." I want to be honest about what that phone call cost me, because I think people expect that I was cold and deliberate and completely unaffected. I was not. I cried in my car before I dialed her number. Not about the money and not about the document. I cried because my son stood in my living room while I was on a prescription painkiller 4 days out of surgery and set papers on the table beside my water glass, and I remembered who he was at 8 years old, and I could not make those 2 people fit together in one picture, no matter how long I tried. Then I dried my face and made the call. That is all there is to it. Maud referred me to an estate attorney named Vivian Bates, in practice 2 miles from where Maud and I had worked together for decades, $2,800 retainer. I wrote the check the same afternoon. Vivian is 54 and has an office above a hardware store and a habit of taking her reading glasses off when she has made a decision, which she did 3 times in our first meeting. She confirmed what I already knew. The amendment was defective on its face. No notary acknowledgement. No valid witnesses as required by the trust's own amendment clause. The trust company had already rejected it. The defect could not be cured retroactively. The document her son had carried to the administrator was, in the language of the statute, without legal effect. She also pointed out something I had noted but not fully weighed. The time beside my signature, 2:19 p.m. on January 14th, could be corroborated against my post-surgical prescription records, which documented a prescribed dose of oxycodone taken at 1:45 that same afternoon. 34 minutes before my son arrived. 74 minutes before I signed. There is a legal standard in Virginia regarding whether a person possesses the mental capacity required to execute a valid trust document. Vivian did not tell me this was a certainty. She told me it was a layer. A documented, time-stamped layer that no one could now remove from the record. That was all I needed to hear. I did not call my son after Easter. I did not confront my daughter-in-law. I did not ask Rowena to clear Martin's chair at the next family dinner. What I did was methodical and quiet and completed before anyone had time to adjust their story. I sent a certified letter to Blue Ridge Trust, formally confirming that the January 14th amendment was without legal effect and should be permanently closed without processing. I sent a second certified letter instructing them to require my direct written authorization before accepting any document bearing my signature from any third party, and I had Vivian draft and execute a proper trust amendment, signed by me, witnessed by 2 members of her staff, notarized by a licensed Virginia notary public, and delivered to Blue Ridge by certified mail with return receipt requested. The new amendment did 3 things. It confirmed me as sole trustee with no co-trustee designation of any kind. It named a trust protector, Maud, in her consulting capacity, with the authority to review any subsequent amendment before it could be recorded. And, in the event of my incapacity, it designated a professional corporate trustee as my successor. Not a family member. A professional institution with a fiduciary obligation to the trust's terms. Blue Ridge acknowledged both letters within 5 business days. The January 14th submission was closed as defective. The new amendment was accepted, recorded, and entered into the account file without question. My total out-of-pocket, Vivian's retainer, 4 additional hours at her hourly rate, and the cost of certified postage, $3,400 and change. My son found out on the 17th of May. Blue Ridge sent him a letter notifying him that his name had been removed from a pending trust designation that had not been accepted, and that the trust account of record remained unchanged. He was at my front door before noon. He came alone. My daughter-in-law called twice while he stood in my kitchen, and he did not answer either call. He said, "What did you do?" I said, "I kept my own paperwork in order." He said, "Mom." His voice had that particular quality it gets when he is searching for a tone that will make me feel responsible for his distress. I have known that voice since he was a teenager. "Mom, we were trying to help you. We were trying to make sure you were taken care of properly." I let that sit for a moment. Then I said, "I know you were, and I need you to understand that the trust is in exactly the condition it should be in." My attorney reviewed it. The trust company reviewed it. When something in my estate needs to change, I will change it through the proper process with proper documentation. Any questions you have about my accounts should come to me in writing from this point forward. He looked at the kitchen floor. Then he looked up and he said something I had been quietly bracing for because I had known it was somewhere in him for a long time. He said, "Do you have any idea what I gave up?" "Not now. When I was a kid, when you had the accident, you were gone so much, and Dad was always working, and I basically managed on my own from the time I was 15, and I have never once asked you for anything." He stopped. I think he heard himself. I had been waiting 26 years for some version of that sentence. I want to be careful here, because I believe it is a real thing he carries. The accident in 1998 was a hard stretch for our family. There was recovery and months of physical therapy, and a period when I was less present than I wanted to be, and I have carried my portion of that weight, honestly. But there is a difference between a debt a parent owes a child and a signature on a trust amendment executed in a living room while the parent is on prescription opioids 4 days out of surgery. He had handed me the second one and called it the first. I said, "Nolan, I am sorry for every part of your childhood that was harder than it should have been. I have meant that for a long time, and I should have said it plainly before now." I also signed my name on January 14th with the time written beside it, and I knew exactly what I was signing, and I need you to understand that those are two entirely separate things, and I am not willing to let them be the same thing. He left without taking anything from the table. I heard his truck back out of the driveway, and then the street went quiet. I went to the closet and got the fireproof box and brought it to the kitchen table and sat with it for a while. Not because I needed anything from it. Because Martin bought it at the hardware store down the road in the fall of 2001 and painted our house number on the side in green paint. His handwriting, still perfectly legible after 23 years. He was a careful man with the things that mattered to him. By July, the situation had resolved itself in the way these things often do when the paperwork is public. My daughter-in-law's cousin, who had apparently been positioned to earn a consultant's origination fee on a financial arrangement built around my trust, quietly let his Virginia credentials lapse following a compliance review at the state level. I learned this from Maud, who learned it from a contact she still has in the licensing office. A rejected trust filing associated with an incapacity claim has a way of appearing in a professional's record, and the next institution that sees his name reads the last one first. Rowena moved back to Charlottesville in June to be closer to her sister. The chair at the head of my table is Martin's again. I have not sat in it and I do not intend to, but I put a cloth napkin on the place setting now when I set the table because it belongs in the full arrangement. On a Saturday morning in August, Phoebe rode her bicycle out to Clover Hill Road. 14 years old, 4 miles, did not tell her mother where she was going. She sat at my kitchen table and drank 2 glasses of sweet tea and told me she had been thinking about becoming an attorney. I asked her what kind. She said she was not sure yet, but the kind that reads all the way to the end of things. I got the original trust document out of the fireproof box, and I turned to Article 9 and I read it to her. I explained what a notary acknowledgement block is for. I explained why execution requirements exist. Not to make transactions complicated, but to ensure that the person signing genuinely understands what they are signing and is themselves when they do it. I explained what capacity means in the context of estate law and why the time matters just as much as the date. She asked if she could read the whole trust. I handed it to her. She sat at my table for 40 minutes and read every page, asking me 3 questions at the end, which were all 3 the right questions. When she got up to leave, she paused at the door and said, "Grandma, I think you should tell people about this, so they know to check their own boxes." She meant the fireproof box. She meant the documents that most people have put somewhere safe and have not looked at in years. She is right. Most households have a box like mine, a closet shelf, a fireproof safe, a file cabinet in the back bedroom. Most people have not opened it since the year they signed the documents in it. And if someone they trusted walked in on an ordinary afternoon with a manila envelope and set it on the table and said, "Just sign here," this is just to make sure everything is protected while you're not feeling well. Most people would pick up the pen, because the person standing there is family, because it feels easier not to ask, because there is always a real kindness somewhere in the sentence, and the real kindness is the part that makes the rest of it so hard to see. Check your box. Find your trust document, your will, your power of attorney, your beneficiary designations. Find out whose name is listed on them beside yours. Someone may have been added quietly, years ago, on a day when it seemed like a practical kindness, on a day when you were not at your most careful. I still wear my mother's apron when I cook. Yellow and white stripes faded, the stain near the hem that has been there for nearly 40 years. I put it on myself now. That is the only difference it needed. If this made you want to open your own box today, that is the only thing I was after. Drop a comment, subscribe, and I will see you next time.